Hi folks, and welcome back to Innovation and IP Law. This is the video series on licensing part 3. And in this video series, we'll look at all of the various different ways that IP agreements can fall foul of that very formidable body of law called the competition law, which is housed in the Competition and Consumer Act of 2010. So looking at the Prezi, let's jump into the overview. Now, what is competition law all about? Well, funnily enough, as its name suggests, it's designed to stimulate and support market competition. And that leads naturally enough to the question, what is market competition? It's behaviour that firms engage in on an open marketplace that is strategic, it's independent of all the other competitors on the market, and it is rivalrous. Okay, so they're all trying to get the maximum market share as they possibly can, vigorously competing. From that very brief description, you can immediately spot the problem, can't you? The statutory IP rights system sets about creating a stack of exclusive monopolies, and obviously where you've got a monopoly, you have pretty much zero competition in that marketplace. You've got one mono operator conducting themselves on the market. So there is a very real risk that prices will go up. In fact, it was thought for many years that the two systems of IP rights and competition law were so fundamentally conflicted that there had to be a specific exception for IP agreements contained within the competition law itself. Otherwise, it was thought that if IP agreements were exposed to the full force of the competition law, that the IP rights system would be undermined. I talk about that a little bit more in your study guide, but suffice to say that Section 51 sub 3 exemption has now disappeared from the competition law, and IP agreements are as subject to the competition law as any other agreement would be. In this video series, we'll take a brief Cook's tour of the Competition and Consumer Act, and in particular Part 4 that regulates anti-competitive agreements, cartels, misuse of substantial market power, exclusive dealing, and price fixing. And it might tantalize you to know that if you like all of this stuff, there is a specific elective on competition law, so look out for that one, folks. Okay. So, looking first at anti-competitive agreements. These are regulated in Section 45 of the CCA, and that basically says that a corporation shall not make or give effect to, so they're two separate provisions, make or give effect to a contract, arrangement or understanding or a concerted practice that has the purpose or effect or likely effect of substantially lessening competition in a market. So we'll have a look at each of these little elements of 45 separately. You should know that even though anti-competitive agreements are prohibited by Section 45, there's a couple of ways that you can get immunity for what would otherwise be a contravention of the provision, and they are the authorisation process and the notification process. I'll talk about notification and authorisation at the end of the video because there's a lot of commonality between the various different provisions. So, contract, arrangement or understanding or concerted practice. What is all that about? So, firstly, what is a contract? Well, we all know what that is. It's a legally binding agreement that can be enforced in a court of law. You have to have all of the elements that we discussed in our contract law unit, so offer, acceptance, consideration. You have to have intention and capacity and privity. It has to be certain and complete, and you can't have any of the vitiating factors involved there. So we know what a contract is. An arrangement or an understanding are both a little bit more nebulous, and there's been quite a bit of case law trying to flesh out what exactly an arrangement is or what an understanding is. In ACCC and Lay Petroleum, the court said that what the CCA does is set out a tiered system, so contract is going to be the most complete and formal means of reaching agreement about some kind of anti-competitive conduct. An arrangement is the next level down in formality from a contract. It's obviously not going to be legally binding, but you do have this meeting of the minds about some kind of conduct that's going to be engaged in. You do also need to have express communication about the conduct being engaged in here. An understanding is more nebulous again, next level down in formality. Again, obviously not legally binding, does require consensus or meeting of the minds, and we have had a rather unfortunate introduction into the notion of understanding, of this idea that you have to have an indication of commitment to act a certain way. That was introduced by case law, which was fairly unfortunate because there's been quite a number of cases now that have come down against the ACCC because the ACCC has not been able to prove that the parties had sufficient commitment to engage in the conduct. So a bit of a loophole there. There was even a review that was conducted around this whole notion of understanding, but unfortunately so far no real clarity yet. In terms of concerted practices, they are even more nebulous again. So you can see there from the explanatory memorandum, any form of cooperation that substitutes cooperation instead of the uncertainty of competition. The uncertainty because you have independent operators on the market that are all making those strategic rivalrous decisions in order to grab their share of competition. So it doesn't reach the level of an understanding, but is more than businesses independently competing in market conditions. Have a look at the guideline that I've linked for you in the study guide. On that, if you're a little bit confused, there is a guideline on concerted practices, and there is another guideline on a nice good general overview guideline actually of contracts, arrangements and understandings. So have a look at those if you want to flesh those notions out a bit further. The next thing, there is the purpose/effect test. So you have to either engage in the conduct with the actual purpose of substantially lessening competition, or the effect of what you're doing has to substantially lessen competition, or even if there's no actual substantial lessening, it must be likely to have the effect of substantially lessening competition. So as you can see, the bottom one there that I've bolded, very regulated friendly provision here, because there needs to be no actual intention and no actual effect. As long as you've got a likely effect of substantially lessening competition, you'll be fine and dandy, and this element will be satisfied. So that's the purpose effect test. The next one is the biggie. So whatever it is that you're agreeing about or acting in some kind of concerted practice about, has to substantially lessen competition. So here we have the Eastern Express case saying that substantial means large or weighty, considerable, solid or big. So a lot of synonyms there to describe substantial. Competition is the process of rivalrous, independent, strategic behaviour, like we were talking about before. So a whole heap of players on the market, all with their boxing gloves on, fighting each other madly to try and grab their slice of market share. What is a lessening of competition? Well, that obviously is diminishing the competition or decreasing the competition, but it can also include things like stamping out emerging competition in a marketplace that wasn't previously competitive. You've got to look at the quality and quantity of competition, and the ACCC applies this with or without test. So you're looking at the market as it is, and then you without the impugned conduct, and then you're looking at what the market would do with the impugned conduct. And if the result of comparing those two is that there was a substantial lessening, then that element will be satisfied. obviously the competition has to be in a marketplace. It doesn't actually say it in the text of Section 45, but this notion of market is swept in by the definition of competition. Market can be a bit of a tricky thing to work out. You see some decisions on this particular point go on for pages and pages and pages just trying to work out exactly what the market is. The Queensland Cooperative Milling case basically says that you look at it, the area of close competition between firms, and you look at whether there is substitutability for the product or service that the parties are providing. The real question at the end of the day is, if the firm gave less and charged more, what would the market reaction be? Okay, so you've got to look at product, you've got to look at geographic market, determine where the location is. You've got to look at level of function, so what level of the supply chain the participants to this contract arrangement or understanding or considered practice are, and also the time. So again, I fleshed that out in the study guide for you. Go and have a look at that. How does this affect IP agreements? Well, the ACCC applies the substantial lessening of competition with or without test mostly by comparing the situation where you've got the impugned license with all of the naughty terms in it that are being objected to, and the situation of having no license at all. You're not comparing it with the situation of having the license but just omitting the impugned provisions, okay? So with the license or without any license at all. The way that the ACCC applies this test is reasonably friendly to IP right holders then, because it's usually going to be the case that the IP holder is going to be encouraging more competition by granting a license, even if it's got some restrictive terms in there, than if they're granting no license at all. The ACCC, in its guideline on the repeal of Section 51 sub 3, which is that exception for IP agreements that we were talking about at the beginning of this video, they said really there's not a whole lot to worry about with the repeal of Section 51.3, particularly in terms of exclusive licenses, because it's very rare that a IP right holder will have such a significant market share that it's going to substantially lessen competition by granting an exclusive license. The same kind of goes for other terms as well, terms like grant backs. Again, it's not going to be very often that an IP right holder has sufficient market share to actually substantially lessen competition in that market just by granting a license with a grant back clause in there. However, you need to be a little bit careful with grant backs. The non-exclusive variety are okay, and the ACCC specifically says that in their guideline, but I'm betting, if I was a betting person, that exclusive grant backs would be looked at much more carefully. You've still got to get over the substantial lessening of competition test, so there is that. But I do think that the ACCC, if it did involve a fairly large market player, I think the ACCC would look very closely at an exclusive grant back, particularly the kind of grant backs that I've seen in some pharmaceutical licenses where, you know, these are typically drafted in US terms, but, you know, they grant an irrevocable royalty-free worldwide grant back to the licensor. So, yeah, those kinds of exclusive grant backs would be, I think, fair game for the ACCC. So that's how Section 45 cuts across IP agreements. And we're around the 15-minute mark now, so I'll finish video 1 off here and I'll skip across to video 2. So until then, bye for now, guys.